Hello everybody. Thank you very much for attending this session on understanding what it means to be GDPR compliant for non-EU vendors. My name is Stéphanie FABER. I'm a lawyer at Squire, Patton, Boggs, which is an international law firm, and I head the data protection practice in the Paris office. I also teach at the University of Sorbonne-Assas in Paris in the diploma for DPOs. This university has an international campus in Dubai, in Singapore and Mauritius, and it is a sponsor to this event. In my practice, I have many clients which are not based in the EU, but which come to me because they want to be GDPR compliant to satisfy the requirements of their clients. GDPR stands for General Data Protection Regulation, and it's an EU regulation that came into force in 2018 to replace a previous directive. It requires organizations to implement a very comprehensive and onerous set of compliance measures. It's more than a check-the-box exercise to have to comply with GDPR. It's actually changing the way to do business. Non-compliance with GDPR may trigger very important fines, financial fines of up to 20 million euros, or 4% of the worldwide turnover, but there are also other sanctions that would require the businesses to change the way in which they use personal data. It is a very complex regulation because it has already given rise to numerous recommendations and guidelines by the EDPB, the European Data Protection Board, which has been set up to harmonize the interpretation of GDPR for all European data protection authorities. So, given how complex and onerous this regulation is, why would a vendor want to comply with GDPR, or to what extent would it have to? The first question is whether GDPR applies to the non-EU vendor as a matter of law because of the fact that it provides services to EU clients that are subject to GDPR. GDPR provides for its territorial scope. There are two types of situations. The first one, and the most unsurprising one, is the fact that it applies to organizations which are established in the European Union. In fact, it's wider than the European Union. It's the EEA. The EEA covers both European member states and 3 additional countries, Iceland, Norway, and Liechtenstein. It does not cover Switzerland, but Switzerland has very similar laws. It no longer covers the UK since Brexit. However, the UK has adopted GDPR before leaving the EU, and therefore some of the things I will say here are also relevant to the UK. So for these organizations, GDPR applies to them wherever they deal with data, even outside of the European Union. But GDPR also applies to organizations which are not based in the EU. This is called the extraterritorial effect of GDPR and is based on the so-called targeting criterion. There are 2 types of activities that a non-EU vendor can do which would trigger application of GDPR. The first one is when this vendor is providing services to European data subjects. It could be a social network, it could be a search engine, or more obvious, maybe an e-commerce website. The second and more relevant activity to this discussion is when a non-EU vendor is monitoring behavior of data subjects in the EU. This could be, for instance, for advertisement purposes, for behavioral advertisement. It could be also to detect identity fraud or credit fraud online, and this could be performed by a vendor which is not based in the EU. But if it entails monitoring of data subject in the EU, GDPR will apply to that activity. This, however, leaves out a lot of non-EU vendor providing services to EU clients. Cloud services, data storage facilities, all of those do not fall under the GDPR by law. So why would they have to be GDPR compliant? Well, the reason for this is that those EU clients who are subject to GDPR have to impose a certain number of measures on the non-EU vendor. It is required for them to implement safeguards so as to make sure that the data, when it leaves the EU, is protected with the same level of protection than if it were handled in the EU. This is called international transfer in GDPR, meaning when EU client either lets access to its data by a non-EU vendor, that could be IT maintenance services, for instance, or when it shares data or asks a non-EU vendor to collect data, or when it stores data outside of Europe. In all those cases, safeguards have to be implemented, and one of the most notorious one is the European Standard Contractual Clauses, also referred to as SCCs. So in most situations, a non-EU vendor will be required by its EU client to sign SCCs. So what are these SCCs? SCCs are actually a very hot topic, but they're generally looked at from the perspective of the EU organization. Today, I would like to discuss them with you from the perspective of the non-EU vendor. What is the non-EU vendor getting into when he has to sign SCCs? A fresh new set of SCCs has been published by the EU Commission in June 2020. These new SCCs have to be applied to any new contract entered into after September 2021, which is already yesterday, and any old SCCs that the vendor may be relying on have to be replaced by the new SCCs by the end of 2022. SCCs, as I said, are intended to create the same level of protection in the relationship between the EU client and the non-EU vendor as GDPR. They are signed between a so-called data exporter, which is meant to be the EU client, and a so-called data importer, which is meant to be the non-EU vendor. One of the specificities of the SCCs is that they have to be governed by an EU law. More precisely, the parties have to choose as a governing law the law of one of the EU member states. They also have to choose to submit to the jurisdiction of one of the member states' courts. This is really important for the non-EU vendor because it has almost another type of extraterritorial effect of GDPR, because each of these EU member states will have GDPR within their legislation. In addition to choosing an EU law as governing law and an EU court, the non-EU vendor will have to agree to submit itself to the jurisdiction of EU supervisory authorities. This means that it will have to answer to any inquiry, accept to be audited, and sometimes also accept enforcement measures decided by the European authority in order to make sure that the SCCs are properly complied with. In addition to all of this, the SCCs also refer back to the GDPR as regards defined terms. You cannot simply read the SCCs and understand what you're committing to. You sometimes also have to go back to GDPR in order to understand what personal data means, for instance, or what processing of personal data means. And these are really, really important concepts because they can be different from what you understand or from what the non-EU vendor understands in relation to PII in its own country. So all of this creates an extraterritorial effect which puts the contractual relationship back into the EU. Another really important specificity of SCCs is that it gives rights to data subject as a third-party beneficiary. Even though they are not a party to the SCCs, they are able to ask enforcement of the SCC before their court. It could be the court decided by the parties in the SCCs, but it also could be the court of the place of residence of this data subject. To this effect, the data subject has a right to ask a copy of the SCCs that you've signed, and it is entitled to ask for damages. It's really important to understand all of this because if there is any kind of damage caused to the data subject for which both parties are responsible, the parties will be jointly and severally liable towards the data subject. And this is something that you cannot contract out. Why can you not contract out of it? Because the SCC provide that it is impossible to modify them. So no flexibility. In fact, they do say that it is possible to include them in a wider contract, and by that it's mainly the services agreement. And they also provide that you can add additional measures or safeguards, I think mainly mechanical clauses, because some parts of SCCs would require to be enhanced by additional provisions such as who pays for the audit or these kind of things. But it is never possible to add clauses that would impair the level of protection given to data subjects and their personal data. The SCC also say that they prevail over any other contractual arrangement that contradicts them. So almost no flexibility. There are, however, a few options in the agreement which the parties have to choose, and they also have to do a little bit of work. In addition to that, it's not simply adhering to the SCCs, they have to complete appendixes. The first appendix is the one where the parties are described, but also the type of services, the type of activity that is done with the personal data. The second appendix describes technical and organizational measures. This means mainly security measures. And the third appendix provides a list of subcontractors of the vendor. This annex is only used when the vendor is a processor. Having set the scene of what it implies to sign a contract, an SCC, the first and most important step that has to take place when signing them is to decide in what capacity the vendor is acting. There are two possible capacities. The first one is that the vendor is a processor, the second that the vendor is a controller. A processor only acts on instruction. The processor may never use the data for its own purpose. The processor assists the client in complying with GDPR. A controller, on the other hand, may use the data for its own purpose. This can arise in two types of situation. Either the vendor has to use the data for other purposes because, for instance, it could be a regulated, performing a regulated activity, such as financial institutions or telcos. They have to do certain things with the data. Or it could be because the vendor wants to use the data for its own purpose. It could be for marketing purposes. It could be for research and development of its products and services, where it cannot use dummy data but wants to use raw data of its clients. So it's really important that the right qualification be used, and the SCCs are modular. They cover all possible situations. Even if the vendor is a controller using the data for its own purpose, it's important to understand that these purposes have to be set out in writing in Annex 1. Anything that is not provided in Annex 1 would not be possible for the vendor. The vendor has to say how it will use the data even for its own purpose, and anything that is not provided cannot be carried out, or the vendor would be in breach of the SCCs. Having set the scene, what do these SCCs contain? As you're not able to modify them, you have to know what you're getting into when you are a non-EU vendor. Their main purpose is to transpose the main principles of GDPR. The main principles are purpose limitation, which means that you have to use the data only for the purpose which is set out in the agreement. There is also storage limitation. Data cannot be kept forever. It has to be deleted at one point. There is transparency. You have to provide information to data subject about what is being done with their data. Another one is accuracy of the data. The data has to be up to date and corrected when necessary. And there are also all the data subject rights, which are either the responsibility of the client or the responsibility of the vendor when it is a data controller. Security is also an important part, obviously, of the SCCs. It is required that both parties make sure that an appropriate level of security is afforded in the context of the type of activity that is being carried out. To this effect, there is an appendix that describes the security measures, but it has to be specific and detailed, and not generic. In addition, SCCs contain specific measures or constraints with respect to so-called sensitive data. This type of data would be health data, sexual preferences, ethnicity, or criminal data. Still on the topic of security, the SCCs contain provisions with regard to data breaches. Obviously, the vendor will be committed to taking appropriate measures to address data breaches. In addition, it is required that he should notify its client if a data breach occurs. And then there are two different types of situations. When the vendor is a controller, he would also have to notify European authorities of the data breach and data subjects. When he is a processor, he should not do so. It is only the controller who has to do it and who has the responsibility. And therefore, in some cases, the vendor has to be careful of not notifying data breaches. The most complex issue, in my view, is the part on onward transfers. Onward transfer covers the case where a vendor has actually subcontractors to assist it in performing the services. So when it has subcontractors, this means that the data will be shared with yet somebody else. This other service provider could be in the same country as the vendor or yet in another country. Here it is required that again the same level of protection is afforded for this transfer to another third party. And the most obvious way of dealing with that is generally for the vendor to have to sign SCCs with this subcontractor, which can be quite complicated, onerous, and surprising for the third-party service provider. In addition, when the vendor is a processor, it needs to obtain prior authorization before using a subcontractor. There are different ways of obtaining this prior authorization, but still, it can be very complex for vendors who have multiple clients and multiple subcontractors to get all these authorizations. So it's something to be aware of, and maybe it's a place where additional provision can be added to the SCCs to better manage the situation. In the case where the vendor is a processor, it will also be responsible for any breach by its subcontractors. The SCCs also require that the vendor carries out certain activities of what we would call accountability and responsibility, which means that the vendor has to document that it is compliant with the SCCs. It has to have written evidence of how it is organizing itself to comply with SCCs. In addition, when the vendor is a processor, he has to agree to be audited by his client and cannot contract out of it yet again. The SCCs expressly say that each party is responsible to the other, but also to data subjects. So this is something you cannot contract out. Last but not least, the SCCs, the new set of SCCs, also address a very recent additional requirement, which is not per se in GDPR, but which is the result of a very notorious case law by the European Court of Justice. I'm talking about the Schrems II case, which has led to the invalidation of the European US Privacy Shield. This decision, which has later been also confirmed by guidance by the European Data Protection Board, requires the parties to carry out a transfer risk assessment. A transfer risk assessment means that the parties have to evaluate and assess whether the law in which the non-EU vendor is based will make it impossible for the vendor to comply with the SCCs. This is mainly aimed at looking at the power that public authorities and surveillance agencies have to get access to data without proper recourse from data subjects or other remedies. So the parties have to assess the legal situation, and the SCCs also provide criteria for making this assessment. And if they decide that there is a risk that the vendor could be prevented from complying with SCCs, then normally the SCCs should not be signed and the service agreement not be entered into. That would be the legal consequence of this assessment. This assessment has to be documented and made available to European authorities if they request it. So it's not something to take lightly, and it's something to be done before signing the contract and the SCCs. It can also raise issues during the life of the contract, because if the law changes in the country of the vendor has to make a new assessment on whether this has an impact on its ability to comply with SCCs. And again, if not, it has to notify the EU client. There are ways to limit the risks created by the legislation, and this is by having additional safeguards, such as, for instance, implementing additional technical measures such as encryption or creating silos of data, which makes it more complicated for the authorities to have access to the data. There is yet another obligation in the SCCs, which is that when it happens that an authority in the country of the vendor requires access to the data, the vendor will have to notify the client of this situation. It will also have, if necessary, to challenge the request by the public authority if it thinks there are legal grounds for that, and it would have to make best efforts to minimize the data that's being accessed to. And it would have to document the whole process and keep the records, so that if an authority, a European authority, requires to see what has happened, there is documentation explaining what has happened. In this situation, the EU client may be forced to terminate the agreement and to cease the relationship. So as you can see, the SCCs are really onerous and require the EU vendor to prepare himself for this situation. Still, it is less than having to comply with GDPR. GDPR requires many more obligations, such as appointing a DPO, making data protection impact assessment, identifying legal basis for processing of personal data. All of this is not a requirement for the EU vendor, even when he's a controller. Also, the other consequence of not being subject to GDPR is that the European authorities should not be able to inflict fines on the non-EU vendor. So, in a way, it's less complex, less onerous, but still, SCCs are very complex and onerous, and EU vendors have to be prepared of what it means to say that one is GDPR compliant in order to satisfy the requirements of its EU clients. Thank you very much for attending this session. I hope it has been a useful perspective for organizations based outside of the EU. Do not hesitate to contact me or one of the other Squire Patton Boggs lawyers should you require assistance in relation to GDPR or other privacy laws. Thank you very much.